What a good-looking group. Good evening. What a beautiful evening this is. It's not too humid, just humid enough to remind us where we are. But it's delightful. I have a feeling that more folks will be coming in, and if they do, and when they do, that's terrific. Just we have some chairs, we'll move them down front. I'd like to welcome you to Historically Speaking. If you haven't been with us before, this is a series of discussions and lectures on the cultural, political, economic, and social importance of St. Mary's County to its people, to us who live here, and indeed to the nation. This is the 11th, I counted them up the other day, this is the 11th program in the series and the 6th that we've done in collaboration with the Center for the Study of Democracy at St. Mary's College of Maryland. My name is Peter Laporte. I'm the Executive Director of the Historical Society, and joining me this evening as host is Dr. Troy Townsend. He's the Interim Director of the Center, while its Director, Tony Uges, is on sabbatical, and Troy is going on sabbatical. He informed me this evening very soon. Troy will moderate the Q&A at the end of the presentation, and he'll offer some closing remarks as well. Before introducing Professor Lasson, a couple of housekeeping items, if you would, please. First, please silence your cell phones. I just did mine, which I always forget, and my wife usually calls me when she's up in PG County at around 7:30, so no call coming through tonight, at least for me. And second, please know that this evening's program is being recorded, video recorded for later publication on the Historical Society's website. Please come down, and there's some seats in the front. Don't be shy. Third, this evening's program is, and all Historically Speaking programs are offered without charge, but that doesn't mean that it's without cost. And if you're not a member of the Historical Society, please consider taking one of these sweet little membership brochures and joining. If you are a member or don't care to join, anything that you could contribute to us would be, however large or small, would be most welcome. We depend, like many 501c3s, on the generosity of others, and in our case, especially those who relish learning about the rich history of this place we call home, St. Mary's County. So, let me turn to this evening's program and speaker. And excuse my sniffles, I have very bad allergies. It is indeed an honor to have Professor Kenneth Lasson with us this evening. Professor Lasson did his undergraduate work at the Johns Hopkins University and earned his JD back in 1966 from the University of Maryland School of Law. He joined the faculty of the University of Baltimore Law School in 1977 and retired there in 2021 and is still teaching periodically as an adjunct professor. His career includes a teaching fellowship at Johns Hopkins, consultant to Ralph Nader's Center for the Study of Responsive Law, director at the Institute for Science and in the public interest, and a visiting fellow and lecturer at Cambridge University in the UK. Professor Lasson is a member of the Bars of Maryland, the United States Court of Appeals for the Fourth Circuit, and the United States Supreme Court. He advocates on a whole host of human rights and civil liberties issues, filing appellate briefs and amicus briefs from time to time. We are also very grateful to have his wife with us this evening. Where did she go? There she is, his lovely wife, Barbara. We just had lunch, a dinner together, and a delightful conversation with her as well. As Marylanders, and particularly as residents of this delightful county, we have at least a passing awareness of Maryland's founding and religious toleration that the Culverts realized when they needed to make adjustments to make this colony work. What is less obvious are the implication of Calvert's practical religious toleration. As our speaker, Professor Kenneth Lasson, stated in the opening of his excellent paper, free exercise in a free state, Maryland's role in religious liberty, and the First Amendment, which, by the way, was the inspiration for this evening's presentation, he stated, and I quote, "Maryland arguably holds the distinction of having been the state whose early history most directly ensured and whose citizens were most directly affected by the First Amendment's guarantee of religious freedom. Because of its relative diverse religious population, why is that doing that? For much of its diversity of its religious population, for much of its colonial experience, Maryland stood out as both a champion of tolerance and a hotbed of discrimination. Similarities have been pointed out between the first provincial government of Maryland and the American plan under the Constitution, particularly with respect to religious liberty," end quote. This leads to what for me is the cheerful observation that Maryland's history and this county's history are deeply woven into the fabric of our nation and our Constitution. And with that, please, a warm welcome for Professor Kenneth Lasson.
Good evening. Thanks very much to Peter Laporte and to the St. Mary's County Historical Society for inviting me this evening to talk about one of my favorite areas of interest, religious freedom in Maryland. The broader topic, of course, is religion in jurisprudence and history and the everlasting challenges presented by the establishment and free exercise clauses to the Constitution, the First Amendment of the Constitution. I say everlasting because new cases seem to come up every year, and we'll talk about some of them later on this evening. But I'd like to begin tonight with the historical backdrop of law and religion in America, going back to the development of the whole concept of religious freedom from a philosophical perspective around the world. Pardon me if, as I read from my notes, but there's a lot of historical fact packed in here, and as an old-fashioned scholar, I like to be as accurate as the original source material allows. I should mention that this is something about the American law school system. It's just to put it into context, law schools are, there are I think over 150 law schools in the United States. Why so many law schools? You know, why some states obviously have more than one law school. The part of the reason is that the American Bar Association ranks law schools. Law school rankings are really quite a subject, and it's quite a bit of competition to get into the rankings. But there can only be a top law school, and Harvard is usually rated number one. Yale and Stanford closely follow, and they of course dispute the number one rankings, and so do the other schools, because a lot of schools like to think that they're the best around. But of the 115 law schools, all of them abide by American Bar Association standards, which means that they're all pretty good. Even a place like the University of Baltimore Law School has to abide by standards. And I say that I'm a native Baltimorean, born and raised, so I'm proud of the city. But the law school is doing pretty well, and it's ranked actually in the top, I believe in the top 10 or 12 in the country for its clinical programs. As a law school, though, it has to struggle to make the top 100. The biggest and the best of I want to put this in perspective too, of law reviews, because a lot of law schools are ranked by the number of law reviews they have. And that brings me to the subject of law reviews themselves. Why do some schools have more than one law review? I mean, how much can you say in a law review? The point of one of the pieces of scholarship that I wrote that appeared in the Harvard Law Review, of all places, was that law reviews are virtually useless. Nobody reads them. And this turned out, I don't know how it got into the Harvard Law Review, which is still considered among many people to be the biggest and the best. But this turned out to be one of the most read law review articles in Harvard's history. How do I know that? Well, they told me, and there was a letter to the editor of the Harvard Law Review. Finally, Harvard has published something that was useful and readable. Well, I like to I took it as a big compliment that it was readable, and you can look it up, and it's called the Scholarship of Mock Excesses in the Pursuit of Truth and Tenure. So it's an attack not only on law reviews but on the whole tenure system, which largely is based in American law schools on how many law reviews you have written in and published in. So you can't get tenure in most law schools until you have written a certain number of law review articles. And this is just ironic because, as I say, very few people read law review articles, and there's a good reason for it. Most of them are virtually unreadable. And I guess one of my favorite footnotes, and because I engage in footnote writing as well, one of my favorite footnotes in this Harvard Law Review article is footnote number 21. It says, "Look it up yourself." In other words, people don't. If they look up the source, it's only as good. You're only as good as your sources, and who knows how good the original sources were. You can't really tell. I mean, historians, I think, are well known among certain people, and cynics among them. Myself being somewhat of a cynic, that historians get their information from who knows that their information is accurate to begin with. Maybe they make some of the things. Well, anyway, as I say, I'm happy to be here and ask you to bear with me as I go through these slides tonight. There you see the title. Let's see if I can get up to the. Okay, there we go. And then we'll get to that title. So here is the statement by King James on the divine right of kings. This statement was uttered sometime around 1600 A.D. He said, "The monarchical state is the most supreme on earth, for kings are not only God's lieutenants on earth and sit upon God's throne, but are called God's even by God himself." The relationship between church and state way back when. Indeed, there followed a long tradition of ensuing British monarchs who viewed themselves as divinely empowered, which, of course, later became one of the primary reasons for the impetus of British commoners to escape England for a freer life elsewhere. It was this quest for religious freedom that was the primary motivating factor in the colonization of North America, and which developed into our concept that American concept, and I think a uniquely American concept, that people of all faiths, as well as those who lack faith, atheists and agnostics, should be free to follow their own religious inclinations without interference from others, and particularly without interference from the government. That idea, however, turned out to be much more of a dream than a reality. At the time of American colonization, for example, England and large parts of Europe itself were in the throes of great religious controversies. The tension was more than just between Catholic and Protestant. Puritans, Presbyterians, Quakers, Methodists, Baptists, and others all had their own particular forms of worship. People who came to America in the 17th and 18th centuries were not so much seeking a land of religious freedom for all as much as they were seeking a place where they could practice their own form of religion free of interference from rival denominations. This is an early colonial prayer meeting. At least one important theme of religion in colonial America was hatred of everything Catholic, believe it or not. As we'll soon see, Catholic Maryland was an exception to the rule of religious exclusionism. But even in the so-called Free State, there were tensions both within and among the surrounding colonies. By the way, the term Free State, I'm not sure if any of you know where the term Free State comes from. Anybody have any idea? I'll give you a hint. It had nothing to do with religion. Nothing to do with religion. Maryland was first recognized as a quote-unquote free state in 1864 when the Maryland Constitution of that year took effect and slavery within the state's borders was abolished. Baltimore, some of you might know, and Maryland fought on both sides of the Civil War. And Baltimore itself fought for both North and South, depending on which area you were from. When by the early 20th century, the term the Free State of Maryland was coined by a fellow named Hamilton Owens, who at that time was the editor of the Baltimore Evening Sun, and it was in celebration of the state's strong stand against prohibition, and it was popularized by the Sun's famous columnist H.L. Mencken. So that's where the Free State comes from. Actually, the Puritans themselves did not accept the principle of religious toleration. They brought with them the conviction that all men have a right and a duty to associate freely for religious purposes, so long as it was in furtherance of the truth faith, that is to say, their version of Christianity. While Puritanism itself was the official faith in Massachusetts Bay, in the Virginia Charter of 1609, the doctrine and rights of the Church of England were established by law. Virginians were specifically told that there was to be no, quote, no innovation in matters of religion, unquote. By the middle of the 17th century, only 2 of the English colonies offered any sort of substantial religious freedom, and they were Rhode Island and Roger Williams' so-called lively experiment in religious liberty, and, of course, Maryland. But the experience in Maryland, I think, was distinct from any of the other colonies, including that of Rhode Island. Its founder and proprietor was a Catholic nobleman whose main purpose was to provide a place of refuge for his co-religionists. And I refer, of course, to George Calvert. At least I call him Calvert. I guess down here they call him Calvert. Calvert or Calvert, it's okay. Oh, okay. Okay. There's George Calvert, the first Lord Baltimore, and from the beginning, he was tolerant of other faiths, welcoming Protestants to the colony, and warning the Catholic settlers to avoid offending them. And his son, Cecil Calvert, followed in that tradition, because George Calvert died before the Charter of Maryland was sealed, and Cecilius, who appears to have inherited his father's benevolent traits, sought to induce Protestants to settle in the province of Maryland, and he told the Catholic settlers that they should practice their religion as privately as possible. In his words, quote, to be silent upon all occasions of discourse concerning matters of religion, unquote. So this is almost revolutionary, or was revolutionary back in those days. He told them that Protestants were to be treated with as much mildness and favor as justice will permit. So here's Maryland's famous Act of Toleration. After 1640, as the Puritans had begun to increase rapidly, Cecil Calvert pressed the General Assembly of Maryland to pass what famously came to be called the Act of Toleration. It was enacted in 1649, and it guaranteed liberty to all members of the Christian faith. So I'll let that sit there for a minute while I go off on one of several tangents I'll engage in this evening. And this is about the curious case of a fellow named Jacob Lombroso. Anybody ever hear of him? Interesting character. Although despite much effort, I couldn't find a picture of him or a photo of him anywhere. But Lombroso was a Jewish doctor who came to Maryland in 1656 to escape religious persecution in his home country of Portugal, where he had lived as a Christian, a Marrano. Once in Maryland, he openly practiced both his profession as a doctor and his Jewish faith. Eventually, however, it came to pass that he met a proselytizing Quaker in a pub one day who asked him a number of theological questions. They just got involved in a debate about religion. And a short time later, it turned out that Lombroso was accused of blasphemy and called to a hearing in which witnesses testified that they'd heard him deny Jesus as the Messiah. He didn't say Jesus was a faker. He thought he was a Jewish prophet, but he denied that Jesus was the Messiah. So it turned out that Lombroso was charged with violating the Act of Toleration, which at that time was a capital offense. And indeed, he was brought to trial. As the luck of the Irish would have it, Lombroso wasn't Irish, but I'll put it that way anyway. The then governor of Maryland, celebrating the accession in 1658 of Richard Cromwell, Oliver's son, as the Lord Protector of England, issued a general pardon to all who, quote, stood indicted, convicted, or condemned to die. And Lombroso's case was therefore unceremoniously dropped from the record. So he was free. The Act of Toleration was liberalized some 7 decades later in 1723, so that a first offense under the Act of Toleration brought a fine and a tongue boring, as your tongue was actually bored. The second, a B for blasphemer, which was branded on the forehead. And you can see that they meant business. And the third conviction, it was the third conviction that brought the death penalty. In fact, though no one was, according to my knowledge, and I'm pretty sure I'm correct on this, no one was ever convicted under the Act of Toleration and sentenced, no one was ever executed under the Act of Toleration. As is often the case with religious issues, a lot of heat, but not much fire. Although Catholics were in control of the government of Maryland in the early years, there was never anything like a legal establishment of Catholicism, nor was there a chance for any English colony anywhere to remain long under Catholic control. Soon enough, though, there came to be substantial agitation for the establishment of Anglicanism in Maryland. The overthrow of James II in 1688 brought a revolt against the Catholic proprietor. Here's where I tell myself, you're getting a little bit too much in history, you're boring the people, but I couldn't cut this out, wasn't able to. And the province was transformed into a royal colony under the control of the Protestants. Official establishment of the English Church came in 1702, bringing Maryland in line with the other colonies in their antipathy towards Catholics. Virginia, New York, North and South Carolina, all were also Church of England. Non-Anglicans were called dissenters. And 2 years later, in 1704, An act was passed in Maryland, in the Maryland General Assembly, making it a crime to say Mass anywhere in the province or to establish Catholic schools. Can you imagine that in today's world? Making it prohibiting the saying of Mass in church, any place in the province of Maryland. By the early 18th century, all 13 of the colonies had some form of state-supported religion, as well as religious requirements for voting or serving in the legislature. Another aside, the Salem witch trials, a word about them. These were a series of hearings and prosecutions for witchcraft, which took place in colonial Massachusetts between February 1692 and May 1693. The most infamous of them were conducted in Salem town, where in 1 year, some 350 people were accused, of whom 19 were hanged. One pressed to death, whatever that meant, and 150 people were sent to prison for blasphemy. Then came the so-called Great Awakening. This was fueled by itinerant preachers who traveled around from colony to colony, urging the citizens to return to their faith in God. The most famous and influential of them was George Whitefield, who toured America in 1738 and fostered religious emotionalism in tent revivals with his fire and brimstone sermons. There were serious divisions in American Protestantism as well, with the so-called Old Lights opposing the Great Awakening and the New Lights supporting it. New Protestant sects were created, which stressed the need for religious toleration, created institutions of higher education, a more sophisticated American clergy, empowered women, introduced revivalism, and emphasized egalitarianism, among other things. Although slave owners feared that conversion might spark rebellion, evangelical churches welcomed black members, both free and slave, and African Americans began to influence the new Christianity. And this happened in Maryland as well, where you had both free slaves and enslaved black people in the state. Although the Revolutionary War, it wasn't a state yet, but although the Revolutionary War was not itself fought over religious matters, the legacy of the religious strife in the world preceding the Revolution provided the impetus for the Founding Fathers to see that, to make sure that religion would not become a divisive issue in the new republic. The Virginia Bill of Rights, for example, written in 1776, stated that, quote, all men are equally entitled to the free exercise of religion according to the dictates of conscience, unquote, from the original Virginia attitude toward religion. It was that Virginia Bill of Rights was written by none other than Thomas Jefferson and endorsed by James Madison. The states gradually began to remove all connections between governments and churches. As the colonists became ever more independent-minded in the 1760s and 1770s, it couldn't escape many of them that the British desire to increase its dominion over American colonies was to be done with the complicity of the church and was supported by English law with King George as its head. Thus, the state controlled religion, and the Church of England helped the state control its people. Thus, the separation of church and state, soon to be embedded in the Bill of Rights, was seen as yet another safeguard against tyranny. In 1776, of course, came the Declaration of Independence, and shortly thereafter, the Revolutionary War. Father John Carroll of Maryland headed the Catholic missions in America. He was named the first bishop in the United States in 1781, as well as the first archbishop in 1784. He also founded Georgetown University. However, it was largely due to Carroll's brother, Charles Carroll of Carrollton, that most Maryland Catholics, as well as those from other colonies, came to support the patriotic cause, and that's Charles Carroll of Carrollton. He was a wealthy Maryland planter and an early advocate of independence from Great Britain. He served as a delegate to the Continental Congress, later as United States Senator for Maryland. He was the only Catholic and the longest lived and last surviving signatory of the Declaration of Independence, dying at the age of 95. So Charles Carroll of Carrollton, you can see if you go back and look at the historical documents, and everybody can get these nowadays online. You don't have to go to the archives of Maryland or archives of the United States to see that Charles Carroll of Carrollton was a signer of the Declaration of Independence. In 1776, the Maryland Constitution was adopted, and Section 33 of the Declaration of the Rights in the Maryland Constitution grants equal protection of the law to all persons professing the Christian religion. The Article 35 went on to state that no other test or qualification ought to be required on admission to any office of trust or profit than such oath of support and fidelity to the state and a declaration of belief in the Christian religion. In other words, Jews and Muslims and Quakers and others and atheists and agnostics could not be lawyers or jurors in Maryland. And in 1789, the Constitution was adopted, and of course religious toleration and freedom became the right of every citizen in 1791 with the passage of the First Amendment. This was largely the achievement of two of the founding fathers, the aforementioned Thomas Jefferson and James Madison. It wasn't until the outbreak of the Revolutionary War that the national attitude in favor of an established religion and against religious liberty began to soften. Virginia, again, led the way with its Declaration of Rights in 1776, and Pennsylvania followed in the same year by guaranteeing all faiths the freedom to worship publicly. Massachusetts followed in 1780, but these measures went primarily towards the free exercise of religion, and even they were not complete. Among the leaders of the American Revolution, practicing Christians were almost as rare as Tories. Men like Jefferson, Benjamin Franklin, Madison, and in all likelihood George Washington himself were called deists. Deists held or thought that God may have created the world, but he departed shortly after getting the universe started, pausing just long enough to lay down the laws of nature. This is one of my favorite quotes. If the infidel views of the Founding Fathers are not familiar to every schoolchild today, it is not because these men were particularly coy about them. Ethan Allen, for example, the captor of Fort Ticonderoga, authored the first anti-Christian book published in America. It was entitled Reason, the Only Oracle of Man. Jefferson, who liked to needle Christian dinner guests with attacks on the character of Jesus, was baited as an atheist in the presidential campaigns of both 1796 and 1800. There was good reason then for the Presbyterian General Assembly of 1798 to lament the young nation's, quote, abounding infidelity, which in many cases tends to atheism itself. At Princeton in 1782, there were only 2 students who identified themselves as Christians. At Dartmouth in 1799, only 1. The less educated among the population circulated Thomas Paine's strongly worded pamphlets. His Age of Reason is said to have converted thousands to infidelity. Thomas Paine. On the frontiers, the early settlers of the West devoted the Sabbath to what one American historian described as riot and drunkenness. No one, therefore, thought it strange that the Constitutional Convention in Philadelphia proceeded without any religious invocations at all, or that the Constitution itself makes only one reference to the deity. Anybody have an idea where where the Constitution, the United States Constitution mentions the deity or God? Well, in a way, it's a trick question. I often ask this to my students. But it's in the date of its signing, which is in the Constitution, on the 17th day of September in the year of our Lord, 1787. That's the way they refer to it, the year of our Lord. The First Amendment explicitly, of course, forbade the federal government from enacting any law respecting a religious establishment, and thus prohibits either designating an official church for the United States or interfering with state and local official churches, which, as we've seen, were common before the Bill of Rights came to pass. But the state governments could still establish churches and make laws limiting free exercise, and Maryland was not one of them. In other words, the First Amendment limits the federal government, not the states. So here we have another of my favorite characters, Thomas Kennedy. Anybody ever heard of him? Well, now you will, and you'll, I think and I hope you'll remember him. Kennedy, I think, authored one of the most remarkable chapters in American history, and one which is largely unremembered. It has to do with an immigrant from Scotland, and as I say, his name is Thomas Kennedy, and it was some 20 years after the founding of Maryland that the colony passed its famous Act of Toleration, which in fact tolerated only those who professed belief in the Trinity and which discriminated against Jews, Quakers, and others. Thomas Kennedy was a Scottish Presbyterian. He came to the New World and settled in Western Maryland. I think at first it was near Frederick, and then he moved to Hagerstown. He was elected to the Maryland House of Delegates. No one asked him to do this. This was what was most remarkable, or is most remarkable to my mind. No one asked him to introduce a bill which was called the Maryland Jew Bill, but he did it. He found out that the Jews weren't able to, Jews and others weren't able to hold public office, and as a member of the Maryland House of Delegates, he wanted to do something about it. He was also founder and publisher of the Hagerstown Mail, which I'm not sure that's still in existence, but it may be. Anybody here from Hagerstown? You know that? The first bill he ever introduced, and the only one that I know of that he ever introduced, that would secure full civil liberties for Maryland's tiny Jewish community, which at that time numbered about 150, none of whom had asked him to do this, was a bill to secure them the right to hold public office. There were only a few thousand of Jews in the whole of the United States, and he introduced this bill called the Maryland Jew Bill. There were no Jews in Hagerstown. Kennedy was not personally acquainted with one. As I say, no one asked him to introduce this bill. His bill was ridiculed as the Jew Bill and Kennedy's Jew Baby. It was defeated by a vote of 50 to 24. He persisted. He reintroduced the same measure in subsequent sessions and was likewise voted down. And finally, this may be the page that I dropped. Finally, he introduced the bill again, and it passed by a vote of 25 to 24, and it was Jews finally had the right to vote in Maryland. Okay, any questions or so far? Yes.
Right to vote or to hold office?
Both, the right to vote and to hold a public office, and to serve in jurors, and to serve as jurors. That didn't happen until 1825. He persisted. He started in the early 1800s, and he kept on pursuing this bill, which to me is a perfect characterization of the good American. He had no religious reason to do this, other than his desire to secure freedom of religion for all. So let's get back to.
Why did he limit it to Jews?
It wasn't just limited to Jews. Well, I'm sorry. He knew that there were 150 Jews in Maryland. To my knowledge, there were no Muslims or Quakers in Maryland at the time.
No, that's wrong.
It was wrong. There were Quakers in Maryland in
Yes.
the early 1800s?
Yeah, up around Montgomery County, Sandy Spring.
Okay, I stand corrected.
And at Eastern Shore in the 1600s.
Okay, I stand corrected, yes.
So the Constitution, the old Constitution didn't require transferring it.
As far as I know, yes.
Quakers are Christian, they're just not Trinitarian.
Right, right.
They were illegal under the original
M-
Act of Toleration.
Yes,
Religion,
yes,
as were Unitarians.
yes.
But I think under the Constitution, it required that you be Christian and be willing to swear on oath.
The Maryland Constitution, yeah, right. As I say, not the United States Constitution. Okay,
So he's picking those who had standing.
yes, that kind of standing, yes. Okay,
Did they include Catholics and Christians?
I think so, yes, yeah, yeah. So, not everybody did. Because the Catholics who founded Maryland, they weren't very well tolerated in the early years. Back to the traditional religion cases. Over the second half of the 20th century, a variety of them have wound their way into the Supreme Court jurisprudence. So before the 20th century, these were relatively rare religion cases. No area has been more hotly debated than the Bible and prayer in the public schools. Does denial of school prayer interfere with the free exercise of religion? Many state cases falling on both sides of the question appeared before the federal question was decided. In 1962, in the case called Engel v. Vitale, the Supreme Court struck down government-drafted school prayer as unconstitutional. First Amendment. Okay, I wanted to mention Reynolds versus the United States, but I can't find it in my notes here. Just bear with me a second. What happens when I don't have the right paper clip that I was looking for? I still can't find it. Reynolds versus the United States was a case involving the Mormons, and that was one of the few cases where the Mormons were not permitted to celebrate their faith out in Utah, and I'll get back to that in a minute. But I wanted to move on to. Let's see if I can get this.
The First Amendment prohibits Congress from passing a law that interferes with an individual's free exercise of religion. Most claims made under the Free Exercise Clause involve requests for exemptions from otherwise constitutional laws that interfere with how a group or individual practices religion. In the 1878 case Reynolds versus United States, a member of the Mormon Church sought such an exemption from a federal law that prohibited the practice of polygamy. George Reynolds was charged with the federal crime of bigamy in Utah after marrying his second wife. At the time, Reynolds was a devout member of the Mormon Church and a believer in its religious doctrine. Under such doctrine, it was the duty of members of the church to practice polygamy. In fact, male members of the church who failed or refused to practice polygamy, when circumstances would permit, would be damned for life. Following a jury trial, Reynolds requested that the court instruct the jury to find him not guilty if it found that he married his second wife in pursuit of his religious beliefs. Specifically, Reynolds argued that the Free Exercise Clause mandated that he be exempted from the law if it interfered with his practice of religion. The trial court denied Reynolds' request, and he was found guilty of bigamy and sentenced to 2 years in prison. Reynolds appealed his conviction to the Supreme Court of the Territory of Utah, which affirmed. The United States Supreme Court granted cert.
So we're moving from the sublime to ridiculous, and this has to do with the Bible and prayer in the public schools. By the way, the Reynolds case was decided in favor of the Mormons. Does denial of school prayer interfere with the free exercise of religion? And as I mentioned, the Engel v. Vitale case struck down government-drafted school prayer. Madeline Murray O'Hare brought a case in 1963, and they involved a Pennsylvania and a Maryland law. Pennsylvania law required the reading of 10 verses from the Bible each day, and the plaintiffs there claimed that it was coercion because the New and Old Testaments, as we know, are substantially different. In Maryland, there was a ruling by the Baltimore City School Commissioners which adopted a rule requiring daily prayer be recited every day in school. I remember when I was growing up in the Baltimore City school system, we had a daily prayer, and sometimes it was from the New Testament, which and I wasn't that familiar with it, being Jewish, wasn't that familiar with the New Testament. But who knew? I mean, kids in school, it's just a ceremony. You know, you're more interested in when recess was coming and what you're going to have for lunch that day, and maybe if you were interested in arithmetic or whatever. The plaintiff in that early case in Maryland was Madeline Murray, who was also an avowed atheist. The court found 8-1 that both the First and the 14th Amendment had been violated. The rights of non-believers are violated, said the court, if public school prayer is either permitted or required. There have been various legislative efforts to make school prayer constitutional, and all of them, many of them actually, there have been many legislative efforts, all of them have failed, as have those by private schools like the Gideon's International to place Bibles in schools. Although I think they still do. People, who's going to complain about that? Kid's going to come home and say, well, we had a Bible in the school. Not going to happen. That brings us to latter day. 1982, Reverend Jerry Falwell and Senator Jesse Helms launched a nationwide campaign in support of an amendment that would permit prayer in public schools. It was carefully drafted. They were permitting it. They weren't requiring it. The proposed amendment read as follows, quote, "Nothing in this Constitution shall be construed to prohibit individual or group prayer in public schools or other public institutions. No person shall be required by the United States or by any state to participate in prayer," unquote. That initiative failed, and it wasn't the first ever in this direction. Similar measures were introduced in 1998, 1999, 2001, 2006. All of them likewise failed, as have a number of state efforts to legislate moments of silence. So what does it take? This is one of my favorite cases too. What does it take to challenge school prayer on constitutional grounds? One must run the risk of public condemnation, ridicule, and perhaps even negative behavior toward family members. Let's look at the case of Lisa Hurdle.
Let us pray let us pray. Till all the world has heard, let us pray. There are souls lost and dying, there are children who are crying.
When you can have a program for 50 plus years and no one objects, the entire community supports this, and then all of a sudden this lady moves in. Now she vows up and down that she was not sent here to do this. But you can understand the suspicion of the people.
I believe in prayer, and I strongly believe in prayer, but I believe in prayer in home and in church.
Who did this and didn't wipe this up?
I think it was just the whole concept of a prayer being said over the intercom for every child to hear. What about the Jewish children, or the Catholic children, or some other belief, or somebody who doesn't believe in God at all? Why are they having to listen to this over the intercom?
Welcome all of you to this morning's press briefing. My name is Tom Andrews. I am the president of People for the American Way. The issue is whether or not government is going to direct religious practice in our schools. That is what is at stake. Freedom, not prayer, freedom.
In fact, we got the one letter in the mail, the death threat. I'll never forget opening up that envelope and seeing that I'll never make it to court. He'll, make sure that I'm dead before I get to court. That scared me. As a parent, when your kids are threatened and their lives are threatened, I think I'm doing what almost anybody would do. I'm not going to take a chance of something happening to my kids. I mean, I'm not going to, somebody walks up to my door, pull out the gun and say, who are you? I'm going to shoot you. But if somebody was to come into my home with a gun or to harm my children in any way, then the gun would come out.
All morals are going to come from the Bible. That prayer over the intercom or the prayer in the gym, however it may be delivered, may help a child in a personal problem. It may prevent a child from cheating on a test. It may prevent a child from
Going through with suicide,
being angry with a friend, or, and a teacher can say, don't do that. And the student says, why not? And the teacher says, because I said so. And the student says, but I see you sin. I see you do wrong. That teacher can say, God says so.
Let us pray, till all the world has heard. Let us pray.
Ho, ho, hey, hey, the First Amendment is here to stay.
Is it right for one person to tell 1,300 kids they can't do it? Is this a democracy? Is this a republic? What are we living? Where are we living? This is the United States of America.
We may be doing a real brief profiles of the lawyers. Is that the correct spelling?
Yes.
And you're Jewish, if you don't mind me asking?
I think our religious beliefs have nothing to do with this case and are completely irrelevant. I don't know where you got that from, and I don't think it's any of your business.
That was just a guess. I didn't know.
Why was that a guess?
That's what one of the ladies told me inside.
I think the religious beliefs of the lawyers in this case have no bearing on this case whatsoever, all right? Mm-hmm. The plaintiff's religious beliefs have no bearing on this case.
In our community, it's anybody who thinks differently or voices their opinion is a minority. So not only have they learned to be put in the shoes of the minority, but they have also learned that no matter how hard it is, that standing up and saying no is absolutely okay to do, even when nobody else agrees with you, even when nobody else stands up with you.
Lisa Hurdall was, I think, she wasn't against prayer. She said, pray when you want, but pray on your own time. Pray in church, or pray on your own time, even if it's school time, and say a prayer, but don't have the school mandated, that is, the government mandated. I should say that after this wave of decisions came down against school prayer, that was, in many ways, I think, the beginning of the private school system, or the flourishing of the private school system in the United States. So a lot of parents pulled their kids out of public schools and started their own, or put them in private schools, or private schools started on their own. I know this happened in Baltimore quite a bit. So the public school enrollments went down and the private school enrollments went up. In other educational contexts, in 1968, Supreme Court upheld a New York law which required the state to supply textbooks to all students, private and public. That was a precursor for the landmark case of Lemon versus Kurtzman in 1971. In this case, a Pennsylvania law provided financial aid to all schools by reimbursing them for salaries and other perks for their teachers. A Rhode Island law provided for direct supplements to teacher salaries. The court decided that the laws in both states, Pennsylvania and Rhode Island, violated the Establishment Clause, and it announced that what has become the so-called Lemon test, which said that for a law to be constitutional, it must have a secular purpose. It can neither advance nor inhibit religion, and it appears to create a situation where the state and religion are excessively entangled. Well, it's easy to say whether the law inhibits or advances religion, or whether it has a secular purpose. But the whole business of excessive entanglement is a very loose term. One person's excessive entanglement is another's important constitutional right. And the Lemon law, I should say, the Lemon test remains the standard to this day. Now, here's something that you might find interesting. The Maryland Annotated Code, Section 7104, provides for, let's see, I have this up here, provides for a daily period of silent meditation. You can read it for yourselves, but I'll go through it quickly. For principals and teachers in each public elementary and secondary school in this state may require all students to be present and participate in opening exercises on each morning of a school day, and to meditate silently for approximately 1 minute. And then B, praying or reading Bible scripture permitted. During this period, a student or a teacher may read the Holy Scripture or pray. I think that's still the law. I mean, it's still on the books in Maryland, believe it or not. So let's see. This was the page I was missing about Thomas Kennedy. As I say, he was the fellow from Hagerstown. He finally got his bill passed by a vote of 26 to 25, with 80 legislators absent or abstaining. This was the bill allowing Jews to vote in whole public office in Maryland. It wasn't until 1961 that the Maryland law requiring a belief in a supreme being in order to hold public office was declared unconstitutional by the Supreme Court. And not until 1976 that the state's constitutional provision prohibiting clergymen from holding public office was struck down. So there was a case back then about a clergyman. I'm not sure what it was, a test case set up by the ACLU or whatever, but a clergyman tried to hold public office and he was not allowed to. Okay, now to some of the other laws, and I'll try and finish up quickly with this. We talked about rentals. The Sunday Blue laws. Have you all ever experienced Sunday Blue laws in Maryland? Yeah. Some of them still exist, don't they? Well, they exist in practice. But it used to be, when I was growing up, you couldn't, under the Maryland Blue laws, you couldn't buy liquor in Maryland on Sundays. Anytime on Sunday. At one point, then I think it changed just to the morning because they didn't want people avoiding church to go down to the local bar. They wanted to encourage church service or attendance in church services. And then it was finally declared unconstitutional. So a number of cases challenged the Sunday closing statutes, the so-called Blue laws. In 1961, a store in Maryland was convicted of violating the state's longstanding blue laws for having sold various items on a Sunday, items, not beer or liquor. And the items were a loose leaf binder, a can of floor wax, a stapler, and a toy. That was a violation of the law in Maryland. This case also went all the way up to the Supreme Court, which found 8-1 that the store's First Amendment rights had not been violated by that law. Justice Douglas was the lone dissenter, saying that Sunday blue laws discriminated against both Jews and one other group, Seventh-day Adventists, right? And there's a big Seventh-day Adventist community in Maryland, particularly. I think there still is in Tacoma Park and elsewhere. So Maryland's blue laws were repealed finally in 1987, and most other blue laws have been repealed in the United States, although Indiana banned the sale of alcoholic beverages on Sundays until that law was repealed just a few years ago in 2018. Many states still ban the selling of cars on Sunday. In 1961, a Maryland law was challenged which required a belief in God in order to hold public office. The Supreme Court unanimously held, and this is a rare case where the Supreme Court in a civil liberties decision is unanimous. Many cases are 5-4. The Supreme Court unanimously found that law unconstitutional and said the government cannot constitutionally force a belief or disbelief in any religion whatsoever. In the workplace, religious benefits and rights of employees are largely protected by Title VII of the Civil Rights Act. But there's been a fair amount of case law in this area. One of my, getting towards the end here, one of my favorite free exercise cases is Goldman versus Weinberger. That's not it. No, I thought I had that in here, but okay. It's a bit of show and tell. Goldman was an Air Force psychologist, an Orthodox Jew who was disciplined for wearing a skull cap while on duty in violation of the military's uniform dress regulations. He sought an exemption, and he was denied this by the military. A 5-4 decision in the Supreme Court held that the regulation did not infringe upon his First Amendment rights. In other words, the majority of the court rejected the strict scrutiny standard that was then in favor of the military necessity doctrine, which accords great deference to the military's professional judgment if the dress codes are applied reasonably and even-handedly. Justice Brennan wrote a characteristically eloquent dissenting opinion, and shortly thereafter, Congress adopted legislation which effectively overturned the court's decision. Lawmakers who worked for the bill's passage sent Brennan a thank you note for his dissenting opinion, and it included a camouflage skull cap. I happen to have a copy of it here. So you can still buy these actually on the internet in a variety of different manifestations. But they had used this. They thought that Brennan deserved it, and he in fact took it with him on a trip he took to Israel, and he wore it every day there in Israel. You can find pictures of that. And finally, where's my clicker here? Oh, thank you. My 10-year-old granddaughter would be able to do this in a second. I'm still the older generation. I remember when I was in law school, we used to pass notes in school because some of the courses were exceedingly boring, and we'd pass handwritten notes the rule was it had to be done in class, and the notes were really the football pool. What were the Colts going to do that Sunday? And we actually had an award ceremony at the end. This was a fast and civil procedure. The professor didn't know what was going on. He just didn't realize it. And we had an award ceremony in class. Nowadays, everything's done by cell phone. My grandkids have 2 cell phones each, so they don't know what I was talking about. Whoever heard of handwriting? They barely know what handwriting is nowadays. So I want to get on to religious holiday displays. In 1984, in a case called Lynch versus Donnelly, the plaintiff challenged an annual Christmas display in Pawtucket, Rhode Island, which consisted of Santa Claus house, a Christmas tree, a banner reading season's greetings, and a creche, which had been part of the display since at least 1943. The court found, again, 5-4 decision, that such a practice did not violate the Establishment Clause. Why? Because it said the creche was passive art in the context of total seasonal display, and it did not violate the Lemon Test. There were dissents by Brennan, Marshall, Stevens, and Blackman. To me, it's, as I tell my students all the time, it's characteristic. Supreme Court will decide what it wants to decide, and then it will find the rules to justify it, and prior cases to justify its ruling. So at first, what ruling does it want to come up with? But there are an inordinate number of cases that end 5-4. The court decided that the creche did violate the Establishment Clause, while the display with the menorah did not. Why? Because the court said that the menorah did not stand alone, but with the Christmas tree, which it said is not regarded today as a religious symbol, and the sign saluting liberty. So taken together, they were not considered an endorsement of religion. On the other hand, the creche was ruled to breach the wall of separation between church and state. Okay, from the sublime perhaps to the ridiculous. Okay. This case happened in 2018, just 5 years ago. Masterpiece Cake Shop versus Colorado Civil Rights Commission, which dealt with the question of whether a business open to the public has a constitutional right to discriminate. The plaintiffs here were 2 male partners who wanted a cake for their wedding. But the bakery owner, in this case a fellow named Jack Phillips, said that he wouldn't bake a cake for a same-sex couple. The state of Colorado charged him with unlawful discrimination, and it fined him. Colorado's courts upheld the commission's order. In other words, he was convicted for trying to follow his religious dictates by not baking a cake for this same-sex couple. Supreme Court heard the case and ruled in favor of the baker, finding that the Colorado Civil Rights Commission had been shown to be hostile to religion because of the remarks of one of its members. The court did not rule on the constitutionality of the commission's findings. So an interesting case, and I think that's the actual cake that was used. And finally, in 2011 case I wanted to point out to you, Supreme Court decided another interesting military case called Snyder v. Phelps. There, the family of Lance Corporal Matthew Snyder, who had been killed in the line of duty for the United States in Iraq while he was serving in Iraq, filed a lawsuit against members of the Westboro Baptist Church for displaying signs at their son's funeral that said, "Thank God for dead soldiers." The family accused the church and its founders of defamation, invasion of privacy, and the intentional infliction of emotional distress. The court held 8-1 in favor of the free speech rights of the demonstrators. In other words, it ruled in favor of those signs. Let's see, there is... I think that's the last case I wanted to mention was a case in 2015, Obergefell versus Hodges, in which the Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. Marriage, it said, is a keystone of our social order. Wrote none other than conservative Chief Justice John Roberts, adding that the plaintiffs were seeking the fundamental right of equal dignity in the eyes of the law. That decision, I'd like to point out in closing, was by a close 5-4 vote, which I dare say is typical of most Supreme Court decisions on matters of civil liberties. The remarkable thing to me, this is what I want to close with, is that Americans of all stripes, whether they agree or they disagree with the rulings of the Supreme Court, largely and peaceably abide by them. So that I don't think happens in other countries. But here, whether you disagree or not, you follow the Supreme Court's decision. So I think that's enough for tonight.
Except FDR, we tried to stiff the court, add more.
Yeah, right. It didn't work. Back in 1945, didn't work. Okay, so I'm happy to take any questions if we have time for them. Or...
So if you would, we have Professor Townsend's going to have a mic, and we're going to have another one to pass around. Please wait until the microphone comes to you so that we can capture your questions and everybody can hear them.
I think we have time for a few questions.
I was interested, earlier you were talking about prayers in the school systems. I'm a member of the Board of Education here in the county, and every meeting we stand up and pledge the allegiance. Of course, in the Pledge of Allegiance, under God.
Under God.
And I just was curious, when you were making that statement, is there any violation that the board is doing based on the separation of religion?
It's a question that's been asked before, among other people, and the answer is that there are opinions on both sides. Some people say that's an absolute violation of the Constitution because under God is in there. Others say it's de minimis, and that's what the court, I think, would hold is de minimis. That means it really doesn't account for much. Who really, does anybody really notice? Now, I guess, did they say the Pledge of Allegiance at ball games now in the seventh inning? They used to do that at the Oriole games. They don't do that anymore. But a lot of people object to the inclusion of the phrase "under God." Kids don't care. They don't come home and say, "Guess what? We said a prayer and it said under God." And the parents, any parent who goes down and protests that has too much time on their hands, probably. But so their opinions go both ways. Other questions?
You had there a part of the Maryland statutes, 7104, I think it said.
7104, I think.
Huh?
7104, it's still on the books.
Yes. And the second paragraph said that teachers could teach from the Holy Scriptures. And
Yes.
The question is the Koran a Holy Scripture?
Well, to some it is. I mean, there's some that's a Holy Scripture, the Quran, and I think, to my mind, that's patently unconstitutional for a teacher to say, now we are going to say this prayer. If you don't want to say it, you can go outside. What kid is going to go outside, or what kid is going to protest? No kid's going to want to stand outside and be the object of interest or curiosity or scorn by his fellow students. They're just going to stay there. So I think it's patently unconstitutional for a teacher to require that or to read from the script. Go say a prayer on your own. Pray to yourself. Before an exam, I know a lot of people pray, especially in law school, before an exam. Who cares? You do it to yourself. But for a law professor to get up and say, now we're going to have a prayer for those of you who are afraid to take this exam, would be patently unconstitutional.
One over here, and then Kelsey.
She said that was law, though, right? It isn't our law.
It's still in the books. And I dare say that there are plenty of school systems. I'll bet you there are plenty of school systems in Maryland. I'd like to do it. The most recent survey I did was already maybe 8 years ago, so it's outdated. But I think there are plenty of school systems in Maryland that still have a prayer every day before school and opening exercises. They still have them. So who's going to complain? The kids not going to go home and complain. So I think it still happens a lot in practice. Because, religion is a subject that continues to this day. It's a hot issue. People debate this every day, religion.
You say that, but isn't that how Madeline Murray O'Hare got started with her case? I'm from Baltimore County, and I remember that very well.
Yeah.
But didn't her son go home from school and complain? And that's how that got started.
Some was, I think, William Murray, who, he was part of the lawsuit, but I think, if I'm not mistaken, he became a born-again Christian and a church-going, a weekly church-going member, so he split from his mother on that.
But then that story still has a horrible ending because was it the son or the mother who was found dead?
I think so. I believe, I'm not sure if they ever solved that case, but
he murdered her.
Did somebody?
He murdered her. The son murdered her.
This son murdered her?
Yes, the son murdered her.
I wasn't aware of that. Okay.
He blamed her for a lot of her issues. He came back and murdered her.
Yeah, and may have had psychological problems himself. I'm not sure that the murder was on religious issues.
Well, my memory is the son did go home and complain to her, and then she made issue whatever.
I think you're right. Yeah, that's what brought it to her attention. But my memory is that she happened to attend school one day. She happened to attend when they were opening exercise. Just happened to attend because I think her son was late, and she brought him there, and that's how she heard the prayer. That's what started. That's my recollection of it. Yes.
Yeah. My question. I'm not sure if it's relevant or not, but in Maryland, prior to the Revolution, Catholics were somewhat put upon to not be able to freely practice their religion.
In the early 1700s, they couldn't say Mass.
Right. That went on until the Revolutionary War. I was just wondering if that influenced what I think maybe is a fairly strong support of the Revolution by Catholics in Maryland, so we could attain religious freedom.
I think you're right. Because Catholics were a very strong presence in Maryland, but they were discriminated against. Early on, they were discriminated against. And then at one point they took control and they were, and then it went back and forth. But right, yeah. Catholics founded by Catholics, they were routinely discriminated against. Yes.
I guess my history recollection is Catholics established Maryland, and for years and years and years you had Leonard Calvert as your governor, then you had Benedict Leonard as Calvert.
Yeah, that's where Leonardtown comes from, I think, Leonard County.
From Benedict, which is weird. So I guess I'm confused because I've heard that several times this evening. I was always given the impression that Maryland was basically the birthplace of Catholicism. That I don't ever.
It was, but it didn't take them long before they were discriminated. Catholics were discriminated against.
Okay, but when are you saying that they couldn't hold office? Because you have hundreds of years.
Early 1700s.
Well, how do you explain Benedict Calvert? Benedict Calvert was a Protestant?
No.
The Calverts converted to the Anglican Church, and they were
Right.
given all their rights from that.
They changed to
From
Anglicanism.
Oh.
Anglicanism, yeah.
Okay.
You can, I mean, they're
I
interesting.
appreciate that. Yeah, and they kept their, they were, yeah, you still had 5 of them if they converted.
It's an interesting history.
And when did they convert? I'm sorry.
1715,
1715, that early,
Yeah.
okay.
So it's
I
an interesting
appreciate
history.
that.
It goes back and forth. Part of this history you can read in my article, or you can hear it from people like me. I like to say that I've been to Ireland and I've kissed the Blarney Stone, so I have to gift the gab. So I can go on and on about this, but don't trust me as, no pun intended, as the gospel truth, because history wavers, and my interpretation of history is different from others.
Then somebody else is correct.
Yeah.
Where may we obtain your paper?
Oh, it's you can get it online. The easiest way is to get it online, and you can also, and you get it online. You can print it out, and that's what I did. That's how I get it now. Although I haven't, as I say, in the old days we used to have reprints, and I have some reprints.
To your question, if you're interested in the paper, send me an email, director@stmaryshistory.org, and I'd be happy to send you a copy of it.
Thanks.
Just quickly, you mentioned about people migrating due to the prayer issue, but there was also an intervening factor that was in there too, was the civil rights movement was also a factor in the movement into the private schools. Not so much in this area, but definitely in the southern states and some surrounding areas due to the issues of segregation.
After Brown versus Board of Education.
Correct.
Yeah. Right. Yes.
So I would like to ask you about the Native Americans down on the religious highway, the Tolerance Highway Road. But because at St. Mary's College, you see a lot of the archaeological sites. But I guess not more importantly, but I think I'm wondering, the question I'll ask you instead is, what do you think the role is now for that religious highway all the way from Point Lookout Road to Leonardtown and even northbound?
What do you mean by, what is the?
I guess,
Does it violate the law?
No. I guess, for the past 2-3 years that I've lived here, I've driven down that road on a daily basis, and I always see the sign religious.
Yeah, I passed that today, but what does it mean, religious highway?
Exactly. So I had to kind of, I didn't know that the religious tolerance was that for certain religious groups.
The government, I'm sure that highway was named by some government group, and for civil libertarians, the answer is you don't like it, protest the government, and go to your legislator and say, how can you let this happen? My guess is nobody cared. So what do you call this? It's called the religious holiday. I passed it on the way down here. Religious highway. So what does that mean? It's just the name of it. It's the name of a road. Okay, Religious Freedom Trail, and why not? Okay, and why not? Maryland government has the right to name streets or roads anything it wants.
But it leads to the freedom of conscience.
Could you wait for the microphone, please? Because we can't hear you.
Sorry.
Somebody from the audience probably can. In St. Mary's County, so around the Revolution, I assumed it was pretty much Anglican, but at some point, the numbers to the Catholic faith, took off, and now it's predominantly. Was there a law about raising children? Do you know that, Henry, or anything?
Raising children?
Raising them as if a Protestant married a Catholic, the child would be raised as a Catholic. There you go. Okay.
Yeah.
So there was no law.
And that to me would be patently unconstitutional as well.
Well, it was a long time ago.
Yeah, right.
I'm listening.
But these cases come up all the time. Religious fundamentalists are still around.
But that was never any law type of thing.
Yeah, and if the parents agreed, they have a right to raise their children the way they want.
They could look at the couples work at it.
I hesitate to say this because it's going to come out very controversial, and I don't intend it to be. But we are in St. Mary's County, named after one of the holiest women in Christianity. What does that say about separation of church and state? And I'm not supporting it, I'm just saying hypothetically.
Who named St. Mary's County?
The Catholics.
Yeah, and what is the problem with that? It's counties have different names.
It's not a problem, but I just
I don't see where it's a constitutional problem. It might be people might not want to move here because it's named St. Mary's County, but I can't imagine that happening nowadays. You move here for the climate, the ambiance, the beauty of the scenery, so on and so forth. Yes.
What about Mary Land, which was not the name, it wasn't mother-in-law, or for Henry and Maria, right? Charles.
Yeah, right. And as I mentioned, Maryland was originally granted in Newfoundland, and it was unhospitable climate up there. So that was the origin of the state of Maryland. But,
George Cabot never made it here. He made it to Newfoundland.
right. It was Cecilia Sue.
So, St. Mary's City is named for Henrietta Maria, who could not ascend to the throne with her husband because she was Catholic. They would not crown her as queen, so she was queen consort. Sort of like Diana was the people's princess. But what I wanted to say to the young man from the college, I don't know this for a fact, but I think the religious highway is dedicated partly because it leads to the freedom of conscience statue. And you go to the college, do you know where it is?
I don't go to college.
It's in front of the post office. And that statue commemorates the act of toleration. So that could be how come this highway exists. It's part of the history of our county.
Interesting, too. I don't know if I mentioned this before, but the church, did I mention that the first church building and the first state house in St. Mary's City were on opposite sides of the, there were separate buildings, and that was one of the earliest manifestations of separation of church and state in America. I don't know if I mentioned that.
Actually, it's a tourism designation.
It's a what?
The highway. The highway. It's a tourism destination.
Oh.
It's a designation from tourism, the State Department of Tourism.
I see.
So that's where that comes from. If you go to their website, it's a whole listing of different things of interest. So that's how they do it. So that if you have a group that's interested in religious issues, that's a thing that they can follow and coming down. So it's another way to gain money through the system. So that's what it's not. It's not a plug of X or Y, because there's one that's an African American trail. There's one that's another trail. It's for businesses. There's a technological corridor. There's these other things and designations to draw attention, and they're tied into larger things across the state. There's 1812, and Eastern Shore has the Harriet Tubman trail. It's the same sort of deal. So it's kind of like we don't have gators, we have things like this. So.
All right. In the interest of time, we're going to conclude tonight's event. Thank you all for your wonderful questions and lively conversation. And let's all please thank Professor Lasson for a nice presentation.
You're welcome. My pleasure. Thank you. Yeah, if you want to close with a prayer, it's okay.
Do that on your own time. Before you leave, though, since I am the interim director of the Center for the Study of Democracy at St. Mary's College, I would like to say that we appreciate the relationship we have with St. Mary's County Historical Society, and we'd like to thank Peter for all the work that he does to put these events together. So please thank Peter and his team. remind you that on August 5th at 5 p.m. in Leonardtown at Tudor Hall, there will be the 2023 Member Social featuring the newly restored Arc Cannon. You don't want to miss it. You can register online. Also, this fall in the new Performing Arts Building at St. Mary's College, our center's next event will be, speaking of the Supreme Court, we'll be hosting NPR correspondent and Supreme Court expert Nina Totenberg on September 12th at 7 p.m. She'll speak about her career in journalism and recent court cases. We hope that you'll join us for these events. In the back, there is a flyer of two of our events. One's Nina Totenberg and one's Jelani Cobb in October. Thank you, and have a good night.